what's wrong with that? Say nice to you.
What it seems to me legal cost finance may be in a position to provide is a way to assist the middleman for whom state funding either no longer exists or for whom state funding is no longer adequate. If the state refuses to honour its obligation to fund equal access to justice, there must be something we, the legal profession, can do to mitigate the problem. Enter Dr. Yuri Rappaport and Legal Cost Finance, for this venture is his brainchild. I'm going to leave the mechanics to others. I can't pretend to understand the detail, but I've had two lengthy discussions with Yuri myself, he having approached me presumably because of the equal access to justice point. But it seems to me that it's a way potentially in which those who don't have the means to pay properly, privately, in the way that some of us know the meaning of the word, or those who simply don't qualify for legal aid, advice and representation, can arrange to finance it themselves. Legal cost finance, therefore, is a potential vehicle for the future. It's an opportunity that I, for one, would like to explore because of the bee that I have in my particular bonnet. The venture is already underway. It has, it seemed to me, enormous potential, not just to benefit the profession I love, but to benefit the clients we serve. So it's not simply a commercial enterprise, although, of course, commercial enterprise it is, in association with the Bar Council, and the two are now associated. It should be well placed to ensure that the commercial incentive behind it is balanced by the need to assist the bar and its customers to provide access to justice.
We have to pay additional access. Barco is now in its third year. As I say, it is now growing. What we are now looking for is more and more areas of work that we can assist the bar. So when we met with Yuri and we looked at the legal cost finance model, what we concluded was that the two fitted together and took this very, very neatly. What we are prepared to do, working with legal cost finance, because it once again reduces some of the administrative burden for us, is that we're going to be able to very soon offer a reduced commission fee that we take for our administration services if it's used in line with legal cost finance. With my not Barco hat on, but my other hats on, I have the Bar Council, which is where we agreed the arrangement with Yuri for legal cost finance. We only echo what Sarah has already said, in that this is a way for many people to be able to finance legal proceedings that otherwise they might not be able to do. Barco then adds the ability for you, as a practitioner, to actually handle those funds within the code. There are many clever ways that people try to get around the code of conduct prohibition on handling client money. I would say not really worth it. There is a solution, and that solution is Barco.
Good evening, everyone. Before I start, I'd like to take this opportunity to thank the wonderful staff of the Bar Council and wonderful staff of the Temple for lending their support to Legal Cost Finance and for helping with today's seminar. And I'd also like to thank, personally, the illustrious panel of speakers that we have assembled today. And of course, in particular, our delightful chairperson, Sarah, has graciously agreed to help me out in managing this event. They were all very kind to volunteer their time to this seminar to enlighten us about the new opportunities and developments for the bar. And as they agreed to take part in today's event for the simple reason that they care about the future of the bar and the future of the legal profession as a whole, which I think deserves a round of applause. Right, so what I'm going to talk to you about today is crucially an important aspect of legal practice. Whilst many of us strive towards achieving the best results for our clients, the thing that also inspires us to work tirelessly without compromising our standards is the satisfaction of clients actually paying our fees. And in all honesty, the process of getting our fees paid, whether in advance or on completion of a legal matter, can be a highly challenging and time-consuming exercise. Now, the problem here is that clients are usually very happy to accept legal advice and representation, but are not always happy or entirely amenable for a variety of reasons when it comes to paying for it. Exacerbating this problem, as we heard today, the recent cuts in legal aid, which have resulted in less funding being available for clients. And to make things even worse, the recent increase in court fees has seen the cost of justice go up. So what we have emerging here effectively is a brave modern world of legal practice. And whether we like it or not, many of us will eventually have no choice but to face the realities of market forces. Now, those barristers practice in the public access arena will need to start thinking more about the consumer mindset as it relates directly to the issue of securing new instructions. After all, understanding your client's needs is essential to working directly with your clients. And building a successful public access practice is all about ensuring that you are fully equipped to remain in the competition for new clients. Now, to achieve this, barristers will have to start doing what service providers in other consumer-facing industries have been doing for years in order to understand their customers. For example, let's take consumer-facing services such as estate agents, motor car dealers, retailers, insurers, and even dentists these days. You'll note that all these services are not linked to any form of government funding. And yet, despite this, these services have learned how to thrive. And that's primarily because they all, without exception, have figured out what the public access bar is only now beginning to understand. And it's really very simple. To get your clients to pay for expensive items, such as a new home, a new car, or legal services for that matter, you must offer a convenient payment solution. Let's consider for the moment payment solutions such as the common home mortgage, or auto finance, or credit cards, or even dental plan, a payment solution for the high cost of dental services. You'll note that all the above solutions are underpinned by some form of credit facility. And this begs the question, why isn't the legal profession doing the same thing? Why isn't the legal profession relying more on private sector finance? Frankly, I'm not sure, but to me, it just seems very obvious and logical that if you're a barrister who wants to get your fees paid on account or upfront, particularly if it's a large amount, that you would go beyond simply announcing your fee to your client, that you realise that making legal services cheaper through direct public access doesn't automatically mean that that your services become cheap. In fact, barristers through direct public access can still be quite costly for clients, which is why barristers must consider offering clients an affordable payment method. Now, I believe there's a genuine opportunity for barristers to harness the unique selling point of public access But not only it lowers the cost of legal services, but makes legal services more accessible to consumers. In fact, projecting 10 years into the future, I'll bet that the large majority of public access barristers will be offering finance to clients as a standard part of their legal fee structure. At the moment, however, most barristers feel uncomfortable about venturing beyond strict professional boundaries and discussing payment options with their clients, which is perfectly okay if they're prepared to accept that the barrister next door, who may be professionally just as good, has enough foresight to offer prospective new clients convenient payment alternatives. Now, the point I'm trying to make is that conservative professionalism in legal practice, although very important, needs to be better balanced with modern commercial realities. And that's because clients are playing an increasingly decisive role in modern legal practice. If you don't believe me, then simply ask your regulator. The Bar Standards Board has been advocating direct public access for barristers for 10 years now. If anything, that's quite a distinctive beacon calling out for barristers to evolve their practices towards the needs of today's consumer. Now, the underlying theme of that evolution is obviously professional survival. And that is not only a matter of how good you are as a barrister, but it's also about making it easy for your clients to pay your bills. And guess what? At the end of the day, the more convenience you offer your clients in terms of payment, the more funds you're likely to receive. So let's take a closer look at the issue of how barristers can provide convenient payment solutions by way of finance to their clients. Now, I need to be very clear here. I'm not talking about litigation funding. Litigation funding is not strictly a financing solution. It's more akin to an investment product, enabling a funder to claim a stake in the outcome of a legal case. Now, investing into legal cases as a means of obtaining funds for clients has so far proven to be highly laborious, with only about 8% of cases, usually high quantum matters, actually attracting funding. In total contrast, what I'll be talking about is a straight credit solution in the form of a payment plan. Now let's take a closer look at how payment plans can work in practice. To set the scene, what I'd like to do now is show you a quick video which explains the legal cost finance solution, and we'll then have a look at one specific example from a case study that I recently encountered. But keep the video now, please.
Nobody wanted to know me because I didn't have the funds to pay up front. I told them I had a steady job and that I could pay their fees over time. But all the solicitors and barristers just shut their doors on me.
Not having the money to pay my lawyer made me scared and angry at the same time. I wasn't even angry with him. He just wanted money for doing his job. I was angry with the system.
It's really quite common for clients to feel anxious about legal costs. They want their lawyers to invest in their cause, to believe in the promise of a windfall, and to take the leap of faith together, so to speak. But in reality, lawyers can't always do that. They have financial commitments of their own to take care of. And so the legal services market needs a solution that would see a much broader section of clients being able to afford paying for legal services.
It took me by total surprise. When he said that their firm offered payment plans to clients, I couldn't believe my ears. I even asked him again. You did say that I could pay your fees by small instalments over an extended period.
I said, what? How come I've never heard of it before? After I just spent months convincing 3 different barristers to take my case on a no-win, no-fee basis, thanks to legal cost finance, I suddenly had the power to choose the barrister I wanted.
We set out to transform the legal services market We wanted to introduce payment plans on a meaningful scale that would enable greater affordability of legal fees at a time when it was most needed. But it's the finance behind the payment plans that plays the most significant role. It provides the necessary funds to cover lawyers' current and future billing, while offering clients the opportunity to repay the credit facility by small instalments over a convenient time period. Overall, legal cost finance helps to restore the dented revenues enjoyed by legal service providers while improving access to justice for clients through highly convenient payment solutions.
The most ingenious thing about legal cost finance is that it effectively costs clients nothing to use the payment plan facility. That's because the financing behind the solution is entirely cost neutral. In other words, the interest rate is simply offset by a discount on a barrister's bill. It's like having a free loan to pay your lawyer.
For me, legal cost finance presents an opportunity to secure instructions that I would otherwise turn away.
I was able to pay my legal costs and then be off my payment plan early from the money the court awarded me. I would never have seen that windfall if it wasn't for legal cost finance.
Yes, I am expecting it to have a positive effect on our revenues. I don't see how it couldn't.
Okay, I apologise for the sound of the video. I thought it was going to go through both speakers, but for those of you who couldn't quite catch what the video was about, there is a copy of it on the front page of our website, so at your leisure, please have a look at that. So what I'd like to do now is to read to you the following example from a case study that I recently encountered. It starts with a client who directly approached the barrister's chambers via direct public access scheme, seeking assistance with her claim against a landlord. Now, the senior clerk at Chambers referred the client to an appropriate barrister and arranged an initial consultation. At that meeting with the client, the barrister provided a cost estimate of £10,000 to run the client's claim. The meeting ended on an encouraging note, with the client saying that she felt the fee was reasonable and that she would most likely proceed with her claim. Subsequently, the barrister sent the client his engagement terms, seeking an initial payment on account of £5,000, which was to be held in Barco. Now, 2 weeks later, the client had not returned the signed engagement terms, nor made any further contact with the clerk or the barrister, a situation which most of you are no doubt familiar with. The clerk decided to call the client, asking whether she was intending to proceed with instructing the barrister, as the barrister was soon to be allocated to another matter. Now, the client's response was non-committal, saying that she needed a bit more time to make a decision, etc., another familiar situation. However, in response, the clerk happened to ask the client if she was aware that she could pay her legal costs by small instalments over time, instead of paying the £5,000 in advance. Now, the clerk went on to explain how this payment plan option worked. The clerk emphasised that the client would not need to pay anything from her own pocket, and that a third-party financier, legal cost finance in this case, would pay the full £10,000 fee to the barrister on the client's behalf. The client would then repay the £10,000 conveniently by affordable instalments over an extended period, for example, 3 years. The clerk also mentioned that the decision on the client's eligibility for legal cost finance could be made within only 24 hours, which is distinctly different again to litigation funding, which can take months of due diligence. Also, the clerk told the client that no personal security was required to qualify for the specialised payment plan. The only criteria were the client's creditworthiness and the ability to make repayments. Now, it so happened that this client was experiencing cash flow problems at the time, and this prevented her from committing to instructing the barrister. However, since she had no previous issues with her credit history, the client saw legal cost finance as an opportune way to commence her claim immediately without having to outlay a substantial amount of money from her pocket. Moreover, if the client was to win her case, she could repay legal cost finance in full at any time without penalties for early repayment. The clerk provided the client's details to legal cost finance, and within a matter of a couple of days, legal cost finance proceeded to approve the £10,000 in favour of the barrister's future fees. Now, incidentally, this particular clerk recommended to all his barristers in his set to amend their engagement terms and include a standard payment plan clause. He felt that the clause would provide his barristers with a competitive advantage over other chambers. This would in turn benefit his chamber's revenue-generating abilities. And he was right. 3 months later, he reported to me a revenue increase of 18% after implementing payment plans for most of his public access clients. So what this means is that routinely mentioning the option of a payment plan to prospective clients can be a very effective way to offer your services, as opposed to approaching clients with the mission of procuring a large amount up front. So I put it to you that it'll be those barristers who understand and accommodate their clients' needs for convenience and affordability that will survive this current evolutionary challenge. And it will be these barristers who will inevitably prosper in the brave modern world of legal practice. Thank you very much. And I'd just like to draw your attention to the fact that we have a questionnaire on the seat next to you. If you wouldn't mind taking a couple of minutes to fill it out, that would be great help for us. Thank you very much.